Because we see all too many people who do come in and they've already signed that release.
Right.
And we can try to walk it back, but there's sometimes if the language is vague enough and things like that, that's how we kind of do it. And there obviously is duress there too, because this person's obviously under stress. But the vagueness is what really gets it, I think, a lot of times, is the fact that they don't know what their medical bills are. How could they contemplate $10,000 in medical bills as part of the contract? There's no meeting of the minds. We're not talking about contract law.
Right. And if you're not familiar with the way that medical bills work and how inflated they can be, then, 10,000 seems like a lot. I mean, that's nothing, as far as medical bills are concerned.
Yeah. And I would say the other thing people don't understand is, this, even if, someone's out there thinking, oh, well, what if the insurance company offered $100,000 on a conditional release? Problem is, if you have health insurance, you've seen it. I've seen it. Most people probably have seen it on their EOBs from their insurance company. Those insurance companies are paying pennies on the dollar. So what that insurance company is doing, even if they say we'll pay $100,000 and then give you $5,000 now, well, if they get that $50,000 ER bill and your Medicaid paid $500 of it, well, that insurance company is going to basically get off by paying that $500 reimbursement to Medicaid, and the rest of that money is going to stay in their pocket.
And why? So why is that important in South Carolina?
That's very important in South Carolina.
Why don't they want attorneys to have that information?
Because in South Carolina, well, they don't want claimants to know that.
Yeah.
Because in South Carolina, your damages are what you're charged.
Right.
So it doesn't matter, collateral source rule.
Yeah.
It does not matter what your insurance pays. Whether it be $1 out of that $50,000. Your damages are $50,000.
Right. So on $100,000 totality of medical bills owed, Blue Cross Blue Shield pays for 70% of it. 25% of it's written off, so you really only owe $5,000. A jury, they're going to award $100,000 if they consider all of those special damages. It's inadmissible.
Yeah.
So
exactly.
So going back to what you were saying earlier, I mean, that's I think that kind of is a pretty good example of why sometimes insurance companies are like, because
that's one of the reasons.
Don't talk to an attorney, because I mean, why would you necessarily know that's about the collateral source rule?
And another thing that they do, another tactic people should watch out for, is they will say, because I've had clients tell me this several times, what they will say is, you don't need to talk to an attorney because it's going to drag your case on for years.
Right. And also, let me just say this, just to go back to what I said, that $100,000, that was purely an example for simplicity purposes.
Yes.
Don't want any adjusters listening to think that that's, I mean, if you get a $100,000 medical bill, you are in the hole as far as that. But anyways, just an example.
I know what you mean.
Yeah.
But yeah, I think that's another reason that they do it, is they try to scare people off from talking to an attorney. I think that they say, I think I've had clients tell me that the insurance adjuster will say, there's no way you're not going to get more than this after you pay an attorney, which is usually patently false. And then also, it does take more time. Obviously, we're not going to be able to schedule, or we're not going to be able to settle a case within 48 hours of a wreck, but it's still just a tactic. These are just the things they're trying to. Long story short, is both of these tactics are to try to resolve your case as cheaply as possible, and before you can talk to an attorney.
Right.
Because most people know, most insurance adjusters know, they know that someone may not go to an attorney the next day or the day after a wreck or whatever. But what they do know is they want to get in front of them before they get in front of us.
Right.
And like you said, we're not trying to say everyone has to come to us, but just talk to someone.
I don't
think I've ever seen a personal injury practice that charges for a consultation.
No.
If you find one, then just go to another one.
Yeah.
But just use that free consultation at the very least. Talk about it. Tell the attorney what happened in the wreck. What kind of treatment you at least remember maybe getting at the ER. Like, again, you may not know your bill, but if you tell us that you had 2 CT scans, 3 X-rays, we can tell. And then if we're looking at a piece of paper where they're going to offer you $1,000 and you have 3 broken ribs, we can at least tell you whether or not you're going to have a decent case or not. And at the very least, even if you decide not to hire that attorney should, if they're worth their salt, is going to at least give you some knowledge so you know your rights.
Right.
And that way you're not. And what people don't understand is when you sign that release, you're waiving your legal rights away.
Right.
You know, you were releasing that driver forever. Again, they can be voided, possibly. But if everything is done correctly and all the boxes are checked, you have now precluded your right. It doesn't matter if in 6 months you need massive surgery.
Right.
So that's the big thing first, is just that those first initial contacts with the insurance company are just chock full of different pitfalls and tactics that they're using to try to get your case done as cheaply as possible before you talk to an attorney.
Yeah. But tell me a little bit about the, treatment gap conundrum.
Yeah.
Just go into that
So the gap in treatment thing comes up a lot. And I think, first of all, adjusters live in this fantasy land. No gray area, black and white, very much just if you went more than 5 days without going to the doctor, then you must not be hurt. And there is some, that there is some legal basis for a gap in treatment, because they know that their attorney, if it ever got to that, their defense attorney is going to be able to put doubt in a jury's mind of what if something else happened. If you got in a wreck and you waited 3 weeks and then you went to the doctor, said you had back pain. Well, did you sleep funny? I mean, we're getting to the age now you sleep funny and you have back pain.
Right.
Or did you do something at home? Did you lift something? Was it a work injury? Anytime that there's something right there may be enough doubt, to get that jury to say, okay, maybe there's some sort of cause that breaks the chain of causation here.
Right. So, or just the argument of were they really hurting if it took.
Exactly. But I think that's the basis for it, but they abuse it.
Yeah.
And like you just said, a few days, are they really hurt? That's kind of what we've heard. I've heard adjusters even tell me, well, your client waited, 5 days between going to the emergency room and going to the, their primary care doctor for a follow-up. Well, you and I in the real world and everyone in the real world also knows that it takes time to get into an appointment.
Right. And one thing that I've seen, I've seen 3 times now, specifically, is a situation where a client doesn't, one, where there was a family doctor, we call it primary care physician, 2, where there wasn't, where in the medical records themselves, I think one was MUSC Chester and maybe the other MUSC Lancaster, and then I think maybe Piedmont. Anyways, in the records themselves, which, something being in the records is important, but also it was obviously said by medical personnel, clear letters like, if this doesn't get better in 24 hours, if it gets worse, come back to the emergency room. Then the adjusters or defense attorneys, dealing with litigation, say we're not going to consider the emergency treatment for day 2 or day 3 because it wasn't necessary. Why didn't I've heard people say, why didn't you go to urgent care? Why didn't you do X, Y, or Z? Well, if you are hurting, first of all, you're following medical advice. Secondly, if you call your primary care physician, hey, when can I come see you? What about, insert date 3 weeks from now on a Tuesday, where they can just refer you somewhere else? What if you actually are hurting? You want to go somewhere, and if you wait that amount of 3 weeks, like this is part of the the conundrum, then they're saying, how much were you actually hurting? So it's like it really is like a damned if you do, damned if you don't situation, right?
It is.
Like in a lot of cases.
We talk about that all the time. It's like, okay, did you get too much treatment or not enough treatment?
Right.
And there's no gray area. I mean, there's no middle line.
Yeah.
It's either always too much or not enough.